During cross-examination, can the defense lawyer ask my medical expert what it is that he and I spoke about before he got up to testify during this trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Now, the answer is yes, he can ask him that question. However, you should know a couple of things. This is unlike the attorney-client privilege. So for example, let's say you're the injured victim, the injured patient, and you brought a medical malpractice lawsuit against your doctor claiming that he violated the basic standards of medical care, causing you significant harm and injury. And now you are on the witness stand. The defense lawyer is now cross-examining you. And during the course of his questioning, he turns around and says, "Hey, Mrs. Jones, what did you and Mr. Oginski talk about before you got up to testify?" Now, what do you think I'm going to do? I'm going to jump up out of my seat, say, "Objection, Judge. That conversation is confidential and privileged." And you know what the judge is going to say? "You're absolutely right, Mr. Oginski. Defense counsel, you cannot ask that question. Anything that the attorney and client have said is confidential and privileged. You know better." Okay, so he knows that that's not appropriate, but yet he asks it anyway. Why? Because he wants to insinuate to the jury that you and I spoke and that I told you what to say, or that I gave you some advice that the jury should know about, but now we're hiding behind this attorney-client privilege. So now let's focus on what happens with a medical expert. The relationship between a medical expert and the attorney who hires him is significantly different than the attorney-client relationship. There is no attorney-client privilege with a doctor or an expert that we hire to come in to support our case. Our medical expert is coming in to testify. He's taking time away from his practice, away from his business, to come in and explain to the jury, number one, that there was wrongdoing, number two, that the wrongdoing caused injury, and number three, that the injury is significant or permanent. So now, when the defense lawyer gets up to cross-examine my medical expert, he can go ahead and say, "Hey, Dr. Expert, what is it that you and Mr. Oginski talked about before you got up to testify?" So now you should know something. The doctor will be required to answer that question. There is no confidentiality there. However, you should know that the best trial attorneys in New York are ones who prepare the doctor, prepare their experts for that exact question. You know what we tell the doctor? Tell the truth. Tell them what we told you. Tell him what you told me. And what did you tell me? You told me that after reviewing all of my client's medical records, that this doctor, the doctor who treated my client, was careless. That he screwed up. That he violated the basic standards of medical care. That's what you told me. Tell him what else? That as a result of that improper medical care, my client suffered significant injury. Tell him that when he asks that question. Tell him how the injuries are significant and permanent. That's what the doctor's going to say. Why? Because that's the truth. Now, there's some attorneys who turn around and say, "Okay, if the defense lawyer asks you a question about what we spoke about, tell him I said he was a cranky old bastard." Okay? And now, just to give the defense attorney a little twist in the back, the medical expert may turn around and say, "Yeah, Mr. Oginski said that you were a cranky old bastard and I shouldn't argue with you." One of the big problems, one of the disadvantages of having the defense attorney ask my medical expert an open-ended question like that, "Tell us what you talked about," is a twofold problem. You see, during cross-examination, an attorney never, ever wants to ask a question to which they do not know the answer. Why not? Because the answer is always going to hurt you, because you don't know what they're going to say. However, since it's an opposing witness, a hostile witness, you know that anything that comes out of their mouth is going to hurt you in your case. So you don't know what they're going to say. But you want some information, so you have to probe very carefully. The second aspect is that once you open the door and say, "Tell us what Mr. Oginski told you," now all of a sudden, he's now going to tell him everything that we talked about, and that's going to hurt his case as well. So, not only do you not ask a question to which you don't know the answer, but by asking an open-ended question, you are inviting the doctor to go ahead and give a long-winded explanation. And I love that, because the jury gets to know the doctor. They get to listen to the doctor. They get to believe the doctor and trust the doctor the more he talks and the more he explains. He's there as a teacher, as a guide. So why do I share this great information with you? I share it with you because this does happen often. And when it happens, if you're sitting in the courtroom and now you hear it, now you know exactly why and how and what's going on with this. You know, I recognize that you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.